Imagine for a second an organization that's like India's parliamentary embassy to the entire world. It connects our democracy in New Delhi directly to, these global legislative bodies.
Yeah.
But at the same time, it's right here at home, hosting seminars for our own MPs.
That's the Indian Parliamentary Group, the IPG.
Exactly. And today, we're not just summarizing a chapter from Laxmikanth. We're going to connect this diplomatic face of our parliament to the really tough constitutional rules.
Ironclad stuff.
Yeah, the whips, the Anti-Defection Law, the Judicial Oversight, all the things that govern, every single moment of an MP's public life. So if you're preparing for the civil services and you really need to get that nexus between convention law and global engagement, you're in the right place. Welcome to Deep Dive, brought to you with the indispensable insights from the rigorous study material of Simplified UPSC by PPP.
And our mission today is, let's say, laser focus. We want to give you that comprehensive, high-level analysis you need, not just for the prelims questions on the IPG, but for the deep mains questions, the ones about accountability, federalism, and the limits on parliamentary power.
That's the real goal.
Yeah.
Now, before we really jump in, a quick but very important point. If this kind of structured content, saves you hours of just rote reading, and we are pretty sure it does, please take a moment right now, subscribe to the Simplified UPSC by PPP YouTube channel.
It really does help.
It does. And we humbly ask you, if you're in a position to, please consider joining the paid membership. Your support, it's not just a number. It translates directly into the time and the resources we need to do this, to synthesize these dense constitutional texts into clear, usable content for you.
And on that note, we have to give a massive shout out to all of our existing members. Your continued faith, your financial support, it's honestly the bedrock of this entire project. So thank you. Thank you for your commitment to this kind of rigorous preparation.
Absolutely. And while you're there on YouTube, don't forget to hit like on this deep dive. And please share your valuable comments down below. We actually read them. And we use your feedback to make every single deep dive better.
No, for the resources.
Right. Free notes, complete with practice, previous year questions, they're all available on our Telegram channel. The link is right there.
And for those of you aiming for that absolute competitive edge, we have premium notes, they have extra PYQs, detailed model mains answers, and they're accessible on our dedicated Discord channel.
But that's exclusively for our Legend YouTube members. It really is the next level of preparation, so we'd love for you to join us there.
Okay. I think we've set the administrative stage. Now let's do it. Let's peel back that curtain on the Indian Parliamentary Group. Its genesis, its structure, and its really critical dual role on the global democratic stage.
Okay, so let's unpack this. When we talk about the IPG, we're not talking about a body that was created by, a big constitutional amendment or some act of parliament. This is an institution that was formed almost immediately after independence.
That's right. It's a pre-Republican institution, which is fascinating. The ITG is formally designated as an autonomous body.
Autonomous. What does that actually mean in practice?
It means it operates with a degree of independence. It was established way back in 1949, so it really grew out of that Constituent Assembly era. Its purpose is, it's elegantly simple on the surface. Promote personal contacts between members of parliament and act as that crucial formal link between our legislature and global parliamentary bodies.
So its autonomy is key. It keeps it, out of the immediate political crossfire?
Precisely. While it's housed within the parliament complex, it operates outside the direct control of ministerial departments. It belongs to the parliament as a whole, not the government of the day.
And who gets a seat at this table? I mean, is it some kind of exclusive club? Is membership competitive?
No, not at all. And that's really important. It's universally accessible, which really emphasizes its role as a collective body, not some elite policy committee.
So any MP can join?
Any sitting member of the Indian Parliament, both Lok Sabha and Rajya Sabha, can join. There's a membership fee, of course, but it's open to all. And this broad inclusion, it ensures that all the diplomatic efforts and the educational programs, they benefit the entire spectrum of India's legislative experience.
Okay, that covers the current sitting members. But you also mentioned it acts as kind of continuity institution. What happens when an MP's term ends? How does it maintain those ties?
That's where the concept of associate membership comes into play. It's a really smart feature.
Associate membership.
Yes. Former members of parliament, Those who have served their tenure but are no longer sitting members, they can enroll as associate members of the IPG. This is just vital for institutional memory.
So you're tapping into that decades of experience.
Exactly. You can tap into all that legislative experience, especially when you're dealing with complex or long-standing international parliamentary issues. They retain a connection to the parliamentary fraternity, which gives the IPG a lot more depth in its international mandates.
Right. And speaking of those international mandates, this is where the IPG really steps onto the world stage. It's not just, sending a few people here and there. It actually manages India's entire relationship with two major global parliamentary organizations.
It's a crucial dual international mandate. It's the official link between India's parliament and the broader global democratic dialogue.
So function number one, the National Group of the Interparliamentary Union, the IPU.
Absolutely. The IPG is the official national group of the IPU. And you have to understand, the IPU is the oldest and largest organization of national parliaments in the world. People sometimes call it the Parliament of Parliaments.
The Parliament of Parliaments.
It's the main global forum for promoting peace, democracy, and interparliamentary dialogue. So, by being the national group, the IPG coordinates India's attendance at IPU assemblies. It ensures that India's vast legislative experience, think about it, dealing with everything from development and poverty to complex federal legislation, is presented on this global platform.
So we're influencing international standards.
We are influencing standards of governance, human rights, you name it.
Okay, and the second key identity, that links back to our history, right, to the Commonwealth.
That's right. The IPG is the main branch of the Commonwealth Parliamentary Association, or CPA, in India.
And what does the CPA do?
The CPA connects over 180 parliaments and legislatures all across the Commonwealth. Its main job is to foster the exchange of best parliamentary practices, especially those related to the Westminster model. And India, well, as a founding member and the world's largest democracy operating within that framework, our branch is a massive one.
So what's the IPG's role there? Is it just attending meetings?
It's much more than that. The IPG's role is to facilitate technical workshops, study tours, conferences. It's about exchanging expertise on everything from how committees should function to, say, budgetary oversight with our Commonwealth counterparts. It really leverages India's own constitutional innovations for the benefit of smaller democracies.
So the IPG is both representative and an educational body. But beyond just sending delegates, what are the concrete operational activities that members benefit from and that also advance India's diplomatic position?
I'd say the functions are really threefold. First, fostering internal connectivity. Second, providing continuous education. And third, providing logistical and diplomatic assistance for MPs when they travel abroad.
Okay, let's take that first one. Promoting personal contacts between members of parliament. That sounds a bit like, soft power.
It is a form of soft power, but it's incredibly important. In a multi-party system like ours, ensuring there's cross-party dialogue outside the often combative environment of the House is just crucial for legislative effectiveness. It builds relationships.
That makes sense. And what about the more visible diplomatic role?
Well, perhaps the most visible function is arranging addresses to members of parliament by visiting heads of state and government from foreign countries.
Right. When you see a U.S. president or, say, the French premier addressing the Central Hall of Parliament.
Exactly. Those events are organized under the IPG's auspices. And they're not just ceremonial, they are critical instruments of legislative diplomacy. They allow foreign leaders to engage directly with our legislative branch, which reinforces the separation of powers and shows the world India's robust democratic engagement.
Okay, and for the continuous learning part, how does the IPG actually keep its members up to date on all these complex governance issues?
They do it in a few ways. They organize talks by eminent persons under the banner of the IPG. More formally, they schedule seminars and symposia, usually on parliamentary subjects of topical interest. And critically, these are designed to be relevant at both the national and international levels.
Can you give an example?
Sure. A seminar might cover best practices for digital governance. That's a topic that's simultaneously relevant for policy in Delhi and for a debate at the IPU in Geneva. These forums are meant to push MPs beyond their immediate constituency concerns and get them thinking about macro policy and international trends.
And finally, that practical support for members who are traveling. This links right back to its diplomatic function. So if an MP is traveling abroad, what kind of material assistance does the IPG provide?
This is a key practical function. When an IPG member travels abroad in a parliamentary capacity, the IPG gives them essential diplomatic assistance. The most important, tangible thing they get is a letter of introduction.
A letter of introduction.
Yes, and these are addressed to the secretaries of the national groups of the IPU and the secretaries of the CPA branches in the countries the MP is planning to visit. This letter, it instantly validates the member status, and, well, it opens the right doors for official meetings and courtesies.
So it's like a diplomatic passport in a way. It speeds things up. Does our own government machinery get involved?
Oh, absolutely. The Indian missions, our embassies and high commissions in the countries they're visiting, are informed by the IPG headquarters ahead of time. This lets the Indian diplomatic staff provide the necessary assistance and the usual courtesies you'd expect for a visiting member of parliament.
So it's a coordinated effort.
It is. It ensures that the legislator's time abroad is spent on substantive work, not on, getting lost in navigational logistics or protocol confusion. So we've established the IPG as this global face of the Indian legislator. Now we have to turn inward. We have to look at the really rigorous regulatory framework that dictates how these individuals must behave inside the legislative houses.
Right. Because the status that comes with IPG membership, it's all contingent on adhering to some very strict rules. Rules about conduct, party loyalty, and accountability.
It all is.
And this framework, it starts not with the Constitution itself, but with a powerful convention that determines daily attendance and, most importantly, voting. Let's talk about the whip.
The office of the whip is a fascinating constitutional anomaly. It's fascinating because, as you just said, it's entirely based on parliamentary conventions that we inherited from the Westminster
So
system.
it's not in the Constitution.
It's not in the Constitution of India, and it's not in the rules of the House of either the Lok Sabha or the Rajya Sabha. And yet, the whip wields immense power. Arguably, more immediate power over an MP's career than even the Speaker has sometimes.
So what specifically is the whip's mandate, and what are the real political consequences if an MP ignores it?
The whip is a party official appointed by the political party, and their duty is really twofold. First, they have to ensure the attendance of party members. This is especially critical during important legislative debates or, crucially, during a division, which is the formal term for a vote.
Getting your people to show up.
That's half the battle. Second, they have to secure the party line, making sure members vote for or against a particular issue as the party leadership wants. Whips issue these directives, these whips, and they're categorized by how many times the text is underlined.
The one-line, two-line, three-line whips.
Exactly. A single-line whip is just to inform members of a vote. A two-line whip is a bit more serious. Attendance is required. A three-line whip is the most critical, and it is a mandatory directive. It's usually for existential votes like the budget or, of course, a no-confidence motion.
And if a member defies that three-line whip, what happens then?
Members must, unequivocally, follow the whip's directives. If they don't, it exposes them to severe disciplinary action from their party.
What kind of action are we talking about?
It can range from being removed from desirable parliamentary committees to, and this is the most critical part, the party initiating proceedings for their disqualification from the House itself under the Anti-Defection Law. The whip is the party's primary mechanism for enforcing loyalty.
And here's where it gets really interesting, because like you said, the party whip and the Anti-Defection Law, the 10th schedule of the Constitution, they are intrinsically linked. They form the core disciplinary mechanism of our entire legislature.
They are two sides of the same coin.
So let's break it down. What are the 4 key grounds for disqualification under this law?
Okay. The Anti-Defection Law, it was brought in by the 52nd Constitutional Amendment Act in 1985. The whole point was to combat the political instability that was being caused by defections, the Aya Ram Gaya Ram phenomenon.
Right.
The 4 main triggers for disqualification are, first, voluntary resignation. If an elected member voluntarily gives up the membership of the political party that got them elected, and note, voluntarily giving up doesn't need a formal resignation letter.
So conduct can be enough.
Conduct implying abandonment is enough. Publicly opposing your party, voting against it consistently, that can be seen as voluntarily giving up membership.
Okay, that's number 1. What's the second?
The second is defying direction. This links directly to the whip. If an MP votes or abstains from voting in the House, contrary to any direction, the formal whip given by their political party, they can be disqualified. The only way out is if they get prior permission from the party, or if the party condones it within 15 days of the vote.
Right. And what about members who aren't part of a party to begin with, independents?
That's the third ground, independent joining. If an independently elected member joins any political party after their election, they're disqualified.
So they have to remain independent.
For their entire term.
Right.
And the fourth ground covers nominated members. If a nominated member joins any political party after 6 months from the day they take their seat, they too can be disqualified. They have a 6-month window to decide. After that, they must remain unaffiliated.
So that covers elected, independent, and nominated members. But critics always bring up this loophole, right? The merger provision. The 10th schedule does allow for defection if it involves a big chunk of the party.
You've hit on a critical nuance there, specifically paragraph 4 of the 10th schedule.
Yeah.
The law originally had 2 major exceptions, split and merger.
And the split provision is gone now.
Right. The 91st Amendment Act in 2003 got rid of the split exception, which was when 1/3 of a party broke away. It was found to be misused far too often. But the exception for merger remains.
It's not the threshold for a merger is.
If 2/3 of the members of a legislative party agree to merge with another political party, they are not disqualified. This allows for, large-scale political realignments without inviting the penalty of defection, but only if that very high 2/3 threshold is met.
Now, the decision on whether someone should be disqualified, that lies with the presiding officer, the speaker, or the chairman. But that office itself is political, and the decision has often been accused of being weaponized or just delayed indefinitely.
This was a huge problem.
So how did the judiciary step in to ensure some fairness?
The intervention was monumental. The presiding officer is the primary adjudicating authority, that's true. However, the Supreme Court, in the landmark Kihoto Hollohan versus Akilu case in 1992, it affirmed 2 crucial principles.
Okay, what were they?
First, the presiding officer, when deciding a defection case, is acting as a tribunal, not just as a presiding officer. And second, and this is the most important part, the decision of the chairman or the speaker regarding disqualification under this 10th schedule is subject to judicial review.
So the courts can look at it. Why was that so vital in this context?
Because before this judgment, the law actually tried to insulate the speaker's decision from any judicial scrutiny. By allowing review, the Supreme Court ensured that the speaker, despite being a political appointee, could not abuse this immense power arbitrarily or, as you said, delay the decision indefinitely just to help their own party. It ensures that the principles of natural justice are followed.
A necessary check.
A necessary, though some argue, often slow check, because the cases can still wind through the courts for years.
Right. Moving from party loyalty to legislative effectiveness, let's talk about motions. This is how MPs are supposed to hold the executive accountable. And for anyone preparing for exams, the difference between a censure motion and a no-confidence motion is absolutely critical.
It is fundamental to understanding parliamentary accountability. Let's start with the censure motion. This is a specific tool of criticism.
Specific how?
It must state the reasons for its adoption. It has to say, we censure the Council of Ministers for these specific policies or actions. It can be moved against an individual minister, a group of ministers, or the entire council.
And what happens if it passes?
Its passage is a severe reprimand. It's a huge political embarrassment. But, and this is the key difference, it does not compel the government's resignation.
Okay, so contrast that with the real existential threat to a government, the no-confidence motion.
The no-confidence motion is, as you say, the nuclear option. First, it has its own rule in the Lok Sabha, and it requires the support of at least 50 members just to be introduced.
And
Second, and this is critical, it need not state any reasons for its adoption. Of course, the debate will make the reasons clear, but the motion itself is just that this House has no confidence in the Council of Ministers. Third, it can only be moved against the entire Council of Ministers, not an individual.
And the stakes are maximum.
The stakes are everything. If a no-confidence motion passes in the Lok Sabha, the entire Council of Ministers must resign collectively, period. This enforces that core constitutional principle of collective responsibility. The government either enjoys the confidence of the House as a whole, or it falls.
That judicial review mechanism you mentioned for the Anti-Defection Law is so crucial it stops the misuse of those legislative tools. But if the executive has a solid majority, which is pretty common, they can just steamroll legislation through the Lok Sabha.
They can.
And this brings us to the houses themselves. We said IPG membership is open to members of both houses, but the Lok Sabha and Rajya Sabha have very different asymmetrical powers, especially when it comes to India's federal character.
Indeed. The Rajya Sabha, the Council of States, is not just a reviewing chamber or a rubber stamp. It has special exclusive powers that are designed to actively protect the interests of the states within the union framework. This really emphasizes its critical federal role.
So what are the 2 key exclusive powers of the Rajya Sabha that really define this federal protective role?
For that, we have to look at 2 articles in the Constitution. Articles 249 and 312.
Okay, let's start with 249.
All right. Under Article 249, the Rajya Sabha can authorize Parliament to make a law on a subject that is enumerated in the state list.
So it allows the center to legislate on a state subject. That sounds like a big deal.
It's a very big deal, but there are crucial safeguards. It requires a resolution passed by a two-thirds majority of members present and voting in the Rajya Sabha. And critically, this authorization is not permanent. It remains valid for only 1 year.
Only 1 year. Can it be extended?
It can be extended, but only 1 year at a time, through the same process. This provision allows the union to intervene in state matters when it's deemed to be in the national interest, but, and this is the important part, only with the explicit consent of the representative body of the states.
So it provides a necessary but time-bound flexibility. It doesn't permanently take away that power from the states.
Exactly. It doesn't permanently erode the state list.
Okay, what about its other major power, the one concerning bureaucracy?
That falls under Article 312. The Rajya Sabha has the sole power to authorize Parliament to create new All India services, services that are common to both the center and the states.
Like the IAS, IPS.
Exactly. The existing All India services, the IAS, the IPS, and the Indian Forest Service, are these crucial administrative links between the center and states. If the center wants to create a new one, say an All India Judicial Service or an All India Medical Service, it must be initiated and authorized by the Rajya Sabha.
And why is that a federal check?
Because it's a vital check. It ensures the center cannot unilaterally expand its administrative reach and dilute state autonomy without getting the state's explicit legislative agreement through their representatives in the Rajya Sabha. It's a powerful safeguard.
That makes perfect sense. The voice of the states has to greenlight a service that will primarily function in their territories. So, given these different powers, what happens when there's a rare legislative deadlock between the two houses?
The only constitutional mechanism to resolve that kind of impasse is a joint sitting of both houses,
Which is presided over by
the Speaker of the Lok Sabha. And because the Lok Sabha has more members, they usually have the advantage in a joint sitting. However, this mechanism has very strict limitations.
It doesn't apply to all bills.
Not at all. It applies only to ordinary bills and financial bills, but not money bills. Crucially, a joint sitting is not applicable to money bills, where the Lok Sabhas will always prevail, and it's not applicable to constitutional amendment bills. Those require separate passage by special majorities in both houses, no exceptions.
Historically, invoking a joint sitting seems to suggest extremely contentious political times. How rare is this measure, really?
It is extremely rare. Since the Constitution came into effect, the provision for a joint sitting has only been invoked 3 times.
Only 3 times. What were they?
The first was the Dowry Prohibition Bill in 1960. That highlighted a major social issue that was causing legislative division. The second was the Banking Service Commission Repeal Bill in 1977. That was a clear case of a new government wanting to dismantle a legislative legacy of the previous one.
And the third one was more recent.
Yes, the Prevention of Terrorism Bill, or POTA, in 2002. That was perhaps the most politically charged of the 3, passed under immense pressure after the 2001 Parliament attack. It reflected a really deep divide on issues of national security versus civil liberties. The fact that joint sittings are so infrequent, it underscores that usually one house, often the Rajya Sabha, yields, or the government just withdraws or amends the bill to avoid that kind of major confrontation.
Okay, so let's move from these, mechanical constitutional rules to how they apply in the real world. How do the legislative and oversight functions of these IPG members connect directly to the core governance challenges that you see reflected in UPSC examinations?
This is the crucial linkage. If we connect all this to the bigger picture, the deliberative forums that the IPG provides and the actual work done by its members on the floor, it all ultimately feeds into trying to legislate solutions for India's most persistent problems. We can look at, say, 3 major case studies that link these constitutional principles directly to policy outcomes.
All right, case study 1, the enduring relationship between land reform, agriculture productivity, and poverty elimination. How do the directive principles frame this as a legislative necessity?
Well, this challenge is directly rooted in the implementation of the directive principles of state policy, the DPSPs, particularly those aimed at securing socioeconomic justice, like Article 39B and 39C. After independence, Parliament and the state assemblies knew that without a major restructuring of agriculture, poverty could not be eradicated.
So what do the reforms look like?
They were comprehensive. First, the abolition of intermediaries. Laws were passed to get rid of the feudal systems of zamindari and jagirdari and so on, transferring ownership rights to the actual cultivators. Second, tenancy reforms, which secured tenure for tenants and regulated rents. And third, the imposition of ceilings on land holdings to distribute surplus land to the landless.
And that legislative path was really difficult, wasn't it? It required constitutional intervention.
Absolutely. The reforms immediately ran into legal challenges based on fundamental rights, particularly the right to property as it existed then. To protect these social justice reforms, Parliament had to enact the first Constitutional Amendment Act in 1951.
And that introduced the Ninth Schedule.
Exactly. It introduced Article 31A and 31B, which validated these land reform laws and placed them under the Ninth Schedule, insulating them from immediate judicial review. The success or failure of these land reforms, which varied widely from state to state, became a direct determinant of agriculture productivity and consequently the level of rural poverty elimination, a cycle that Parliament must continuously monitor.
Okay, case study 2. This one dives into a critical internal security issue, the growth of left-wing extremism, LWE, and its linkage to governance failures.
This is a direct linkage to administrative shortcomings when it comes to tribal rights. The analysis really centers on the impact of the non-implementation of the Fifth Schedule provisions.
The Fifth Schedule, which governs the administration of scheduled areas and tribes in 10 states.
Correct. When the governance structures in these areas fail to manage things like land alienation, resource extraction, or just fail to provide basic justice and development, the grievances that result feed directly into the narrative of LWE movements.
So what's the operational mechanism that's supposed to implement the spirit of the Fifth Schedule, and where does the governance failure actually happen?
The crucial operational mechanism is the Panchayats Extension to Scheduled Areas Act, or PESA, from 1996. PESA was enacted to extend the provisions of the 73rd Amendment, the Panchayats Amendment, to the scheduled areas. It was meant to grant substantial powers of self-governance to the Gram Sabhas, the village assemblies.
Powers like?
Powers like mandatory consultation on land acquisition, managing minor forest produce, and controlling social sector institutions. The failure occurs because many states have either failed to enact the necessary state laws to complement PESA, or they've enacted laws that are just too weak and don't fully devolve the powers that PESA mandates.
So it's a legislative and administrative lapse.
It is. This non-implementation leaves tribal communities feeling powerless, and that fuels the anti-state narrative that supports LWE growth. It turns it from a pure law and order problem into a deep-seated governance failure problem, rooted in legislative inertia at the state level.
And finally, case study 3. Looking at the economic challenges after liberalization, which is directly relevant to the kind of international dialogue the IPG engages in.
This case study examines the impact of the economic liberalization policies, which were started in 1991, on our own Indian-owned companies and their capacity to compete with multinational corporations, the MNCs.
Right. Before 1991, it was the license Raj and the Pharaoh.
Exactly. A highly regulated and protected economy under the Foreign Exchange Regulation Act. Liberalization through the gates, wide open, introducing intense global competition.
So what legislative actions were needed to manage that huge shift?
Well, first, Parliament had to repeal FEMA and replace it with the less restrictive Foreign Exchange Management Act, FEMA. But beyond that, the legislature must continually address the consequences. Are Indian domestic companies able to access capital and technology? Are the market conditions fair for them to compete, or are they just being overwhelmed?
Just Parliament's role is ongoing.
It's constant. It involves ensuring regulatory fairness, maybe providing targeted support to critical domestic sectors, and setting appropriate FDI limits to prevent complete foreign dominance in a strategic area. This requires ongoing legislative oversight of economic policy, making sure national interests are balanced with global integration, a topic that gets debated a lot in forums like the IPG and the IPU.
Okay, so we've now established the whole parliamentary environment and the major issues that its members have to tackle. But Parliament, it doesn't operate in a vacuum. It doesn't operate unchecked.
Not at all.
There's institutional and judicial oversight to ensure its powers stay within constitutional limits. And we should start with the financial guardian, the Comptroller and Auditor General of India, the CAG.
The CAG is one of the absolute pillars of India's democratic setup. It's often called the guardian of the public purse. The CAG's core constitutional role is to uphold the Constitution and the laws of Parliament in the entire field of financial administration.
So by auditing government accounts, it's making the executive accountable to Parliament.
Exactly. It secures the financial accountability of the executive, the Council of Ministers, to the Parliament. Without the CAG, Parliament would be, for all practical purposes, flying blind financially.
So walk us through that accountability loop. How does the CAG's work actually translate into legislative oversight?
The process is very meticulously structured. The CAG submits 3 primary audit reports to the president.
3 reports.
Yes. The audit report on appropriation accounts, the audit report on finance accounts, and the audit report on public undertakings. The president is then constitutionally mandated to lay these 3 reports before both houses of Parliament.
And once they're on the table?
Once they are tabled, the reports are taken up for detailed examination by the Public Accounts Committee, the PAICs, of Parliament. The PAIC scrutinizes them and then reports its findings back to the House. This is the mechanism by which the legislature investigates any financial impropriety or waste that the auditor has identified.
That sounds pretty robust on paper. Yet, Parliament's actual control over expenditure is often criticized as being, well, weak or ineffective. Why is it that despite the CAG's exhaustive audits, the executive often seems to retain such tight financial control?
This is a critical point for a high-level analysis. The truth is, there are inherent structural and political constraints on parliamentary financial control. Well, first, there's technical complexity. Demands for grants, complex financial instruments, they're often highly technical. Most parliamentarians, they don't have specialized financial expertise, so they can't scrutinize them properly. They have to rely on high-level political guidance.
And the second constraint?
Executive control of the legislative agenda. The executive, the ministry, formulates the budget and controls the legislative timeline. And since the executive almost always has a majority in the Lok Sabha, the chances of effective criticism, let alone passing something like a cut motion to reduce a grant, are minimal.
So the majority just pushes it through. And what about the PETA itself? Does it have limits?
It does. While the PETA is powerful, its findings are advisory. They are not binding on the executive. Furthermore, the PETA only conducts a post-mortem. It's examining expenditure after it has already been incurred. And crucially, the PETA is specifically barred from scrutinizing policy matters. It can only look at financial regularity and propriety.
So the control is?
It tends to be sporadic, general, and largely political rather than technically effective.
So, in essence, the executive asks for the money, Parliament rubber stamps it because of the majority, and the CAG and PAC can only really clean up or point fingers after the fact. That's a powerful institutional limitation.
It is, and it raises a very important question. If Parliament's financial control is so structurally constrained, then how does the judiciary ensure that the legislative actions of Parliament, and by extension, the fundamental rights of every citizen, remain within their constitutional bounds?
This is where we bring in the sentinel on the qui-vive, the ever-watchful Supreme Court. And let's start with one of the most revolutionary shifts in Indian jurisprudence, the case that redefined liberty, the Maneka Gandhi case of 1978.
Before Maneka Gandhi, the prevailing view, which was established way back in the 1950 A.K. Gopalan case, was very restrictive. It was textualist.
What do you mean by that?
The court interpreted Article 21, which says, "No person shall be deprived of life or personal liberty except according to procedure established by law," very, very narrowly. In Gopalan, the court basically held that procedure established by law simply meant a law made by the state, no matter how arbitrary or unfair that law might be.
So as long as the law was passed correctly, it was fine.
Essentially, yes. Protection under Article 21 was only against arbitrary executive action, not arbitrary legislative action. Parliament could pass a bad law, and the courts couldn't strike it down just because it was unfair.
And how did the Maneka Gandhi case completely shatter that restrictive interpretation?
The Maneka Gandhi case fundamentally reinterpreted the concept. The Supreme Court asserted that the procedure established by law must be fair, just, and reasonable. It couldn't be arbitrary. This effectively introduced the American concept of substantive due process into Article 21.
And it did something else, right? It linked the fundamental rights together.
Yes, and this was revolutionary. The court held that Articles 14, equality, 19, freedoms, and 21, life and liberty, are not mutually exclusive silos. They form an interrelated concept, what is often called the Golden Triangle. Any law that seeks to deprive a person of life or personal liberty now has to satisfy the triple requirements of Articles 14, 19, and 21.
The significance of that change, it really can't be overstated. It transformed Article 21 from just a procedural guarantee into this robust guarantee of fundamental human dignity against arbitrary legislative action.
Exactly. It forced Parliament to ensure its laws were not only legally passed, but were also substantively fair. And this standard of fairness was then applied in subsequent, more socially relevant cases, like the Navtej Singh Johar case in 2018.
Right, so detail the impact of the Navtej Singh Johar case on fundamental rights and discrimination.
This case directly challenged that colonial-era legacy embedded in Section 377 of the Indian Penal Code, which criminalized so-called unnatural offenses. It was historically used to persecute the LGBT community. The Supreme Court, using that expanded Maneka Gandhi framework, partly struck down Section 377.
And what did the ruling declare?
The ruling declared the section unconstitutional insofar as it criminalized consensual sexual acts between adults of the same sex.
So what specific fundamental rights violations did the court cite to justify striking down a law that had been on the books for over a century?
The court cited multiple violations, all linking back to that golden triangle. First, Article 14, equality, because it arbitrarily targeted a specific group based on their identity. Second, Article 15, non-discrimination, because it was discrimination solely on the grounds of sexual orientation.
And Article 19.
Article 19, freedoms, because it curtailed the freedom of expression and the ability to choose an intimate partner. And finally, the most critical violation, Article 21, life and liberty. The court said Section 377 denied the right to live a life of dignity, self-determination, and privacy. The judgment affirmed that LGBT persons are entitled to the same fundamental rights as all other citizens, reinforcing the judiciary's role as the final sentinel against legislative actions that fail the test of constitutional morality.
This has been an incredibly layered deep dive. It really shows that the Indian Parliamentary Group, while it's focused on that outward diplomatic engagement, is just intrinsically connected to the internal mechanics of our democracy.
It's two sides of the same coin.
Yeah. We established the IPG as an autonomous body formed way back in 1949 with open membership for all sitting and former MPs. And it provides those critical diplomatic introductions through its role as the national group of the IPU and the main branch of the CPA.
And then we detailed that rigorous system of accountability. It's enforced by the party whip and strictly governed by the Anti-Defection Law of the 10th Schedule. And the decision-making process there is, crucially, subjected to judicial scrutiny under the Kihoto Hollohan judgment to stop it from being used arbitrarily.
We also clarified that key difference between the strategic, but not fatal, censure motion and the resignation mandating no confidence motion.
We did. And then we looked at the structural power dynamics, highlighting that protective federal role of the Rajya Sabha through its special powers under Article 312 for all India services and Article 249 for legislating on state list subjects.
And we connected all these legislative functions to those core governance challenges, from the necessity of land reform to fulfill the DPSPs to how the failure of PESA implementation can fuel LWE, and that ongoing need for Parliament to regulate M&C competition in a liberalized economy.
And finally, we examined the highest checks on parliamentary power. The CAG's oversight, which, despite its advisory limitations, ensures financial accountability. And, of course, the judiciary's role as a sentinel. We saw how the Supreme Court evolved constitutional protection, moving from that restrictive approach of Gopalan to the substantive fairness standard of Maneka Gandhi.
And applied that framework to ensure dignity and non-discrimination in the landmark Navtej Singh Johar ruling.
Exactly.
So as we wrap up this dense analysis, I want to kind of pivot back to where we started. The IPG's focus on promoting internal camaraderie among MPs. Now, considering that many sources related to electoral reform highlight this severe ethical challenge, the nexus between crime and politics, a factor that really undermines legislative integrity, we have to ask a final question.
Go on.
How effectively can a body that is primarily focused on promoting cooperation, friendship, and diplomatic courtesies among legislators also enforce the extremely high ethical standards that are necessary to combat criminality and corruption within its own ranks?
That tension, the tension between institutional fellowship and the need for critical self-scrutiny, that is perhaps the greatest perpetual challenge for any robust parliament. It requires MPs to hold their own peers accountable, even when it breaks that mold of professional camaraderie. That's certainly something to mull over as you study the ethical dimension of governance.
A profound thought. Thank you for joining us for this crucial deep dive into India's parliamentary group and its constitutional context.
And if this level of exhaustive analysis saved you hours of preparation time, please do remember to support the creation of this content. You can do that by subscribing to the Simplified UPSC by PPP YouTube channel. Every time you consider becoming a paid member, you're essentially investing in the detailed production of the next deep dive.
We truly appreciate all our existing Legend members for their critical contribution. And be sure to like this deep dive and share your valuable comments with us below.
And please remember, free notes with practice PYQs are waiting for you right now on the Telegram channel. And the premium notes with extra PYQs and detailed model mains answers are available exclusively on the Discord channel for our Legend YouTube members. So please do join us there to secure that competitive edge.
Until the next deep dive, stay curious and keep connecting those constitutional dots.